This section is about resolving disputes, ADR, or alternative dispute resolution, and voluntary mediation. The IEP team members have a common goal of gaining agreement, and each team member has a point of view. Sometimes that causes disagreements. If you disagree with the district's decisions about your child's referral, assessment, services, or placement, you have several options. Some of these options are at no cost. They are less formal ways to gain agreement, and other options are formal legal steps that may cost families or the district for attorney's fees. If possible, always start informally with the people who are working with your child, but you may choose any of the following options at any time: alternative dispute resolution, or ADR, pre-hearing mediation conference, mediation after requesting a hearing, due process hearing, compliance complaint, or uniform complaint procedures. Alternative dispute resolution, or ADR, is an alternative to legal steps. ADR is a voluntary way to resolve a dispute. ADR may not be used to delay your right to a due process hearing. The SELPA supports ADR at no cost to you or to the district. Some examples of ADR can be a simple phone call to family or staff to clarify information. It could be an IEP meeting facilitated by a neutral party. It can be coaching or consultation to families or to the district staff on options. How does ADR work? Families or district staff can request ADR. It's provided by SELPA staff or by other trained neutral parties. It's voluntary for families and for the district. The North Region SELPA Parent Caregiver ADR Guide on the North Region SELPA website has more details. You can call the SELPA program specialist at 510-525-9800 to request ADR support. A pre-hearing mediation conference allows you and the district to meet with a state mediator without attorneys. A mediation request may be made either before or after a due process hearing request. The conference is informal and it's conducted in a neutral way to resolve issues about the identification, assessment, or educational placement of a child, or about FAPE, free and appropriate public education. The parent or the district may bring or be advised by friends, family, advocates, specialists, or district staff. The parent or district may consult with an attorney prior to or following the conference. You can make a request in writing for a mediation conference by writing to the Office of Administrative Hearing, OAH, at the following address. The OAH can also be contacted by email using the secure e-file transmission system. The SFD may be found on the OAH, the Office of Administrative Hearing website. In deciding whether to use ADR or pre-hearing mediation, remember you have the right to skip the ADR and voluntary pre-hearing mediation steps. However, these meetings can be very successful because you have more control over the solution rather than having a judge make a decision.